Howdy, this is Dr. Stacy Lyle. This is Module 6 in our land in GIS property management. So what we're going to talk about here is adverse possession or possession. Possession is 9/10 of the law, and I'll go through and explain how that works and what it means. But it has to be actual, visible appropriation of real property, and it has to come in for a certain amount of time, and it has to be hostile or against the claim of another. One of the things that you'll see sometimes, I'll take, for example, in my class when I teach this in law, I'll take a pen from a student and I'll say, who owns this pen? And the answer is, I do, because of the 9/10 is possession. So I'm possessing this pen. Now they might have a receipt for this pen, so that would be a piece of paper, which might be a deed showing they purchased it. I might have a piece of paper showing I got it. I will ask the neighboring student nearby to give me a piece of paper quitting any claim that they have to this pen, and then I have a color of title to this pen. Now they might have a clear marketable title. I have a color of title. If I possess this pen over a certain amount of time, it will bar their ownership, but that time limit, let's say it's 3 years or 5 years or 15 years. It's not like at 3 years somebody's going to knock on my door, come hand me a title. It means in 3 years it limits their right to that, and I have the favor of the law on my side. In fact, I have the pen, but in law I need to meet some criteria, so we'll go over that. So typically this happens when titles are adversing each other, and when titles are adversing, that means they're overlapping and somebody's making a claim that their title is trespassing on the other. It's called Trespass To Try Title, and we'll talk about that and pass the remedy. And then we'll apply the law to determine possession and see if it's feasible, that it's actual, in that it has fully matured. Now once they have gotten theirs, their title will hit its limit, and so we'll need to understand that. We're going to do some legal descriptions, look at some record documents and some rules and court cases, but in our assessment we're going to do a land boundary description where we address a adverse possession. I want to quickly go back over the construction of boundary construction concept and look at specifically some other issues. Now we talk about the original deed or the patent, the survey, the map, the detail, the legal description, and the survey. And sometimes the survey or the legal description will cause an adverse possession. When we look at the words that's in there, those sometimes are put in there because we don't know. Words like about, along, and with, these are key legal terms. One way to look at it, I say go lay that water hose about that fence. So you're going to put it across the fence, rolling it out along as you go. If you say along, I'm going to go and touch the water hose as best I can to the fence. If I say with the fence, though, I'm going to take nails and nail that water hose to that fence. If that fence moved, that water hose better move as well. But again, we're looking at the intent, beginning at the northwest corner of the and the southwest property of Williams along Williams South line, right, 1900.8 baras to a point which a 20-inch oak tree bears north 10 baras for the northwest corner of this property of Jones. So they went along here and they said there's this oak that's here that goes to this point. Now, was their intent to put a point that's so far from this tree? Was their intent to go to the northwest corner? I mean, is there a gap here? If we go past that corner, I mean, what's the deal? Are we going to hold their corner? Are we going to gore into them? And if we did gore into them, what happens in that scenario? When a road comes across here and creates problems for us, sometimes it might lie across here and knock out all these pins, which is always a problem. But if I give the road, again, the road becomes senior because the road gets what it gets. And you're going to see when we talk about the road, can I adverse onto the road or intersect with the road? So we'll talk about some of those topics as we go along. Again, there's this concept, they give the quarter, the southwest quarter of the railroad grant. The area of the Smith grant is 168 acres. The railroad grant was 160. Therefore, if they got a quarter, do they get 42 acres, right? Because if they got a quarter, they got a quarter. But there is things like strip and gore doctrine, which means that as you go along these areas, you might cause strip and gore. And I've done things like that where it started here and somebody went to a point in a pin and a point in a pin and a point in a pin and a pin on a stream and that up here, versus where the original survey went from point to point and they caused some strip and gore issues. And then you have issues where people call to the center line of the road or call to the right-of-way, or they fall short of the right-of-way. So we'll talk more about these roads and what happens there, but what I'll talk about more is adverse possession. Again, we've talked about the footsteps of the original surveyor, calls for monuments, okay? So if we have a senior property and this is junior and this is junior, and the original calls for witness points which are found 5 feet from a found iron pin newly set but not called for in any deeds. So if you find something newly set, it's probably not it. But if you find something that is been newly set and it's been called for, well, now it causes a problem, right? So the past one called for this point, and maybe it called for this elm and this post oak along that, and you go find this you dig up an old iron pin there, but the new one that just was done in 2018 is here, right? Well, you would think, okay, they made a mistake, let's move it back here. The problem being is that they have created a title when they set this point right here, and the clock has started. Now, this doesn't look like a big issue, we could move it because we really own that portion. But let's say that if they were to have gone, more up here and went over the property line and set a monument up here. Well, that's a problem. Now they're goring into here. They're not leaving a strip behind. So this gore, you go, okay, well, wait a minute. It needs to be back down here. This one looks, it's just simple, move it up. But the laws or the rules would work the same going from up here to down here. So you have to understand that element of what to do. In that case, what happens is that once they've set this, you have to go back and fix that title. You have to go back and redo the document to move it from here. I mean, it was up here, it needs to move to there. But what happens sometimes when they move it up here, they might have built a house over and they don't want it to move back to there. So it causes a problem. Which is the original survey? Again, we follow the footsteps of the original survey. You go, well, this is the original. The original actually is the one in your hand. You can't go past this survey. It is the original survey. When you're retracing that survey, that's the original, not the one that was done, 100 years ago, or 50 years ago, 5 years ago, or 1 month ago. The one in your hand, the 4 corners, is the one that is the original that you must do. And let's make sure we understand that. A lot of people think the original is the historic one. The original one is the one get a piece of paper. The 4 corners, the one in your hand, okay? All right, so we go through junior, senior rights, follow the footsteps of the original survey, the one in your hand, the intent, what's on the 4 corners, the proper application of the dignity of call, the priority of calls, right? And the applicable statutory court cases to help us to do it. You move from the best to worst, conflict to harmony, fact to parole. Parole is hearsay or oral evidence, like the farmer telling you where he thought the corner was. All right. Now you have locative corners, which is the southwest corner of the Williams 640-acre tract and the Carlo Martinez original patent. All right, that is a general statement. Then you might go to a junior, senior rights, who owns it? Is it the parent tract? Any gaps or gores? The point calls, where did they start? To get to the point of beginning has no greater other interest than any other point. You could go around from any other point in that. And then the monuments, any witness parts, passing calls, they're called descriptive calls. So if you're going up a line and you pass a creek or you go past a tree, those are descriptive calls. They're only used to set the points. You don't snap right to those points. You have these distances, cardinal directions, true north again, magnetic north. All right, so we have to know, do we have true north and magnetic north? What are the acreages? Are they real? All right, so here we can see passive calls. Now the iron pin is maybe locative calls, but if you're this track, you know, thence northeast 200 feet to a oak tree, and thence northeast 300 feet to an iron pin of the Smith tract, thence 400 feet to the center of Plum Creek. So what did they do? Did they intend to make those corners or passing calls? Really difficult, really hard to tell. But you know, there should be locative, should be simple, have meaning. This tree has no meaning. It's not a boundary anyway. You're not going to meander up a line going up through here. You're trying to set that original line down through there. Okay, so understand your adjoins. Again, we've talked about that. Natural monuments, it's the river, not the meanders. It's not the thing being meandered. So if it says to an iron pin, thence along the stream. Now, is the iron pin? Yes, it is the boundary. But as soon as it says to the stream, you make a perpendicular jump to the center of that stream and you follow that stream. If the stream changes at any time, okay, then you would go to that new stream location. If the stream is here, for example, now I've got it as a bank, if you will, but let's say it moved from here to here. Where do I go, okay, to get to that location? Do I keep going up that line, or do I jog 90 degrees to get over to the stream as quick as I can? Typically you continue along that line till you get to the new stream location and then along the stream. So the meanders are never the boundary, just the thing being meanders. Artificials, obviously posts, axles, trees, okay, pipe, pins, all right, I got a description there. Calls for trees, they're artificial or natural. Well, they occur naturally, but they're typically artificial. And then occasionally you'll have at least two calls to two trees, and if you can see those trees, you'll know where they're at, and then you could actually put that pin back in. Okay, now natural streams, you say, oh well, this is a natural stream, and if I was coming up here and I hit an iron pin and hit an iron pin, okay, but now the stream moves. All right, do I have a new location? Well, you would hold that bearing, go up through here till you get to the new stream, ignoring those iron pins, if you will. You could go to that iron pin, then to the next iron pin, then to where the stream crosses again. Okay, so a fence line is never the boundary, unless it's called for in a deed. And you should never call for a fence line in a deed. If you cannot determine the boundary from that position, acquiescence to a fence does not create a normal boundary. Acquiescence, meaning that the parties did nothing, doesn't make it the boundary. Even if they agreed, let's call that the boundary, unless the words of conveyance was used, that I give you everything on that side of the fence and you give me everything on that side of the fence, then it's still just a fence and an agreement to put the fence there, but not a transfer of title. Okay, so distance courses, bearings and distances down through there, Areas have the least amount of dignity. We've talked about junior senior rights already in some details. You know, when you have a section where you go through and you simultaneously convey a piece, you might have each piece gets their portion as they're called for. All right, if there is 250 feet called for, all right, but each piece had their portion add up to that, but you actually find 270 because it was simultaneously conveyed all in one document, one day, a true subdivision, if you will, then everyone gets their piece of the 270, right? So they're going to get the 270 times that each piece will get a portion greater to locate where it's at. All right, so that's the review of that, but let's talk about adverse possession. Adverse possession and prescriptive rights. First off, we'll say trespass to try title. And what does that mean? What are the boundaries a matter of law? Where are the boundaries a matter of fact? Surveyors are fact finders. The court system, which includes the surveyor, is the law. Okay? So a trespass to try action is a method of determining the titles of lands and tenements of real property. And so what happens when you have these properties that might have adverse possession and you're going across some location? So you can see here I have occupation. They're occupying to that stream or to this fence line, but their title calls for here. They might have left some gaps and they might be goring into here. So they have a title to here, but they don't have title to there. If they tried to sell this portion up here, they would need to clear up that title in order to get that. Well, if they find that the landowner to the north actually owns this piece right here, they would have to find a resolution, have it adjudicated, have their title reach its limitation, and this title perfect. So it occurs when it's occupying, when the title finds short, when you find or you show occupation, and it is easy to tell. It must sometimes be written, it must be acknowledged by all the parties, and it must be actually occupied. Okay? You'll hear the words open, notorious, and hostile, meaning you can't subvertly try to take somebody's property. You take their property and you say it's yours. When you own a piece of property, let's be clear, you have rights to do whatever you want. You don't have to ask somebody or your neighbor or anyone, can I build a fence on my piece of property? Yes, you can build a fence on your piece of property. If you don't think it's your property, that's the problem. That's where you need to be open, notorious, and hostile. Have no other ideas that it's your property. A good example of this is a right-of-way once that was in Houston for a transmission line. Landowners backed up to this right-of-way, and it was questioned whether the transmission company had purchased that or just got a easement to that. One of the landowners built over the property line, and he actually was on the news, and he said he contacted the power company and got permission to build into that right away. Right away, he jeopardized his case because you don't need to ask permission to do something on your property. If he was not sure it was his property, why did he ask permission? Okay? So you need to be open, notorious, and hostile. So there is statutes of times to which your title will ripen, or you have that you must bring suit to recover it. It's not like if I'm adversing after 3 years, I've got it. After 3 years, I can bring a lawsuit against those people saying their title's trespassing on mine and I want it. So if you have color of title for 3 years, now this is a good example where a survey was done incorrectly. They set the point over the property, or they set it before. They made a mistake in the deed, in the survey. that is a color of title. It is everyone thinks it's the right title, but it's a color. It has not the clear title. But it was open, notorious, and hostile. They all thought it was theirs, so they ended up, creating that situation. And so in 3 years, you could bring suit against the trespassee and get a perfect title, okay? And once the court has proof and determined your title is perfect and absolute, and they can't come back and argue this again, all right? Not a double jeopardy kind of situation. 5 years, you might have a claim with some deed, like a quit claim. A good example of that, if I go back up here to my boundary, we're going to work on a good case on this situation. And in this scenario, what happened is we have a piece of property where the property originally went to the center line of the creek. Then somebody came in here and went by the meanders and made a deed by the meanders, not the center line of the creek, and they transfer title like that. Well, to remedy it, what needed to do is have somebody up here quit any claim they have on this side, and then they quit any claim they had on that side. So they created a quit claim, which created a color of title, you could say, and they then got that, and it was 5 years. It would not go back. You could not argue that, well, I meant to do this or that. All right, so paying the taxes, helps to set that. Without title, nothing, just stealing land. You can do it. It's not against the law. Limited to 160 acres, all right? 25 years, anything goes. Must cultivate it, must have it, must enjoy it, must be using it. If anyone doesn't come up, it's yours, all right? So that's the term. It must be actual, visible, and correct. A color of title is a document, all right, that is not regular because of some error that it has on its face, a defect. Maybe it is made honestly or fairly by a mistake by a surveyor, all right? Is based on a certificate, a head grant, or land warrant, and sometimes this happens where somebody went out there and surveyed the land, but they don't have an actual patent to it, so they need to. They've got a color of title because they've never fully patented it. That happens in the state of Texas occasionally. Peaceable possession of real property that is continuous and is not interrupted by adverse suit or recovery of the property. So it's continuous. So title is a regular title chain of the sovereignty of the soil 2 year. Now you cannot adverse against somebody that has a disability, anyone that's under the age of 18. So if they got the land from their father and mother when they passed away, you cannot adverse against this. And you cannot adverse against unsound mind. If somebody is, say, mentally disabled, you cannot try to take their land. Or if they're serving in the United States Armed Forces during a time of war conflict, you cannot take their land. Some people often ask me about what if they're in prison. Okay, when you're in prison for a felony, you lose all your rights, and so you could be adverse against very easily and quickly, and so that's not uncommon. If a person is entitled to sue for recovery of property, entitled to make a defense based on the title of the real property is under a legal disability at the time the title of the property vests or adversely commences. The time of disability is not included in the time of the period. So it's just saying, okay, what if, there's a gap there between when they might have been a sound mind and then they had an auto accident and now are disabled. Okay, so they're just saying during that time. A person has the same time to present a claim that is allowed to others. Now, tacking a successful interest, which means I sell it, I adverse it, they sell it, they adverse it, they sell it. You can tack the timeline of adversion, all right? Again, if it's open, notorious, and hostile, it wasn't hidden by any time. But you see, when somebody sometimes buy that, what kind of deed did they get? Could the only thing you could warrant is really what you have, which would be right here. Now you will see a special warranty deed that says I'll warrant what I have. I can't warrant, what I don't have, right? And so you'll see a specialty warranty deed that says I can only warrant my title, not anything else to it. All right? Adverse possession, 3 years. There's some more things about owning it, the period. You can read through that. Now clearly you cannot adverse against the state. And the state meaning that, okay, well, who owns the right-of-way? And this is really intended for right-of-ways. You could adverse against, say, A&M, although it's a state agency. This is really intended a lot for adverse possession of the state. Because the state is the public, and it's who's looking after the property. Well, because it's all of us, it's difficult to put your finger on one person. It should be the DOT, but again, they're public agents. It's difficult from that standpoint. But you can adverse possess against the state. It's rare, but it doesn't occur. Why? Because the state is senior title. When you give them that right away, even if it's a dedication, not a fee taking, and we'll do this next week, then what happens is they are fee and they are where they're at. Now, if you try to build into their right of way and now say, oh, I want to take that, we really get into a junior senior rights. Again, there is no adversion against them, so you could never ripen into a title against the state. All right. Now, there is something called prescriptive rights. Now, prescription take once daily. And prescription is really about right-of-ways. It's not necessarily that land title transfers in possession. When I take the pen, where'd the pen go? When I take the pen, I possess it, right? But if I use it over a long period of time, maybe to go across a piece of property right here, I might have a prescriptive easement. Okay, so prescriptive easement, and it's different for different states. Some are 7 years, 10 years, 5 years. You have or enjoy that easement to ingress and egress to your piece of property. Sometimes, though, I've been in court cases where they have said, well, I've got a location to get to the road, and so the state will say, well, if you have another way you can get to the highway, they might not give you that prescriptive easement. And it's just a ingress and egress. I've seen where, well, okay, they've been driving up and down this road. Their dad drove up and down this road. They actually had the power company come down through here, and the cable company ran a cable to get cable to their house. Okay, that doesn't necessarily give them those rights, and it has to be adjudicated, and it has to be awarded from that standpoint. Now, there's concepts of common reputes, very rare in some incidents where everyone thought this was the corner. The neighborhood thinks this is the corner and acts upon that. But this is a old method of determining location, very rarely worked on. Acquiescence. Acquiescence, it's the favorite Shakespeare, acquiesce to acquiesce. I do nothing about nothing. All right. So acquiesce means not doing anything. So if you acquiesce, meaning you all agree, or you just don't do anything, and the whole time you just treat the fence like the location, then acquiescence might ripen, but it's got to be adjudicated. Acquiescence alone does not create occupation, or occupation alone is not an agreement. All right. If Smith and Jones believed the fence line, though, by paying for half, and Jones built a barn over that, Smith could be estopped or estoppeled because he allowed Jones to injure himself. So if he knew, well, the line really was here, but we agreed upon there, he built the line over to here, then that might be because he acquiesced. Then it could be what you use in the adverse possession elements of thing, and be one of the legal arguments that you put forward. Okay, so that could happen in that scenario. Property line agreements. Now, if we write a property line agreement. So we're going to build a fence here so your cattle can get to water and my cattle can get to water. This is not an intent to transfer title. I'll show you some of this later on, and you'll look at it and you'll see it is not an intent to transfer title. It is an element to be able to actually have something get done. Where is the boundary? It is still the water that is there. So a property line agreement, unless the words of conveyance, I hereby give, convey, bargain, sell, transfer, are used in the deed, it is not adverse possession. Okay, but last thing we'll talk about, let's say that, okay, I have a piece of property that I've been paying the taxes on for years, and I think it's mine. Come to find out it's not mine. What happens to all those taxes I paid? Well, that's called volunteer taxes, and you don't get it back. One of the failures of the system, but that's key. So adverse possession. Now, going all the way back up here and looking at the court cases in the time frames, can mineral rights adversely be transferred? Can you adverse mineral rights of another? So if none of these properties have ever been severed from the minerals and they have actually occupied this, right? All right. They've actually occupied this and thought that this was theirs. And let's say that, in some scenario, maybe this land over here thought the line was here, okay? And he's acted upon that. And he sold the title to the minerals to this, coming down this fence line. He left some here because maybe it went up to this line. So did they adverse the title to this? Can they claim they own the minerals to this piece? Now, it was severed several years ago, and maybe they came back and fixed it and put the fence here, but I've got a piece of paper that says I own the mineral rights going down this line. All right, you go, well, it was a mistake. I've been open, notorious, and hostile. How have you been open, notorious, and hostile? You own mineral rights that have been severed from the surface, and the surface doesn't look anything like the minerals. Well, I've recorded it. I've put it out to the public. I've leased it. I've done everything I can to do it. You'll even see them put advertisements in the newspaper saying that they have an adverse to this title that's right here, and they claim that's them. If they want to rock up and argue these people that they own that, you can adverse mineral rights, but you got to go through the facts specifically on each case and try to truly understand, was there actual, notorious, hostile, was there a cloud of title created? Has that point of time reached its limitation of title? Do we get it adjudicated to fully own it and have it ripen? Then you might have adverse possession of mineral rights. So just think about it as you're just resolving the surface portion, even at that time frame, no matter what's happening up here in the future. But at that time, that when it's severed, if it's severed with an adversion, yes. Right? Now, if the surface moved and changed its mind multiple times, the mineral might still be stuck in this location, getting its adversion from that element. I hope that helps. We'll do a quick exercise to try to understand that, and we'll have some more quizzes to go through this. Good luck.